It's time now for us to get into our big stories, and we are taking a look at the Office of the Special Prosecutor. They've detained Paul Adom-Otchere and 2 others over the Ghana Airports Company Limited contract probe. And these people have been detailed also because they have failed the bail terms. I have lawyer Agyei Baffour Awuah with me on Zoom, and we're going to have this conversation to understand various perspectives. I understand Agyei Baffour Awuah is actually on phone. Thank you for joining us. Good morning and welcome to the AM show. Agyei Baffour Awuah.
Good morning and thanks for having me. Good morning to your listeners and viewers.
Great. So let me start with your initial reaction to the story. When you first heard that the Office of the Special Prosecutor had detained these 3 persons of interest, what were your thoughts?
Well, my thoughts were that when a person is given power to exercise same for and on behalf of the state to achieve a particular end, we should not obstruct that person. However, we should make sure that that person counts for the exercise of that power. And so when the facts are out and we are able to judge for ourselves the reasonableness or otherwise of the exercise of that power, then we need to put judgment to it. What judgment are we putting to it? Question would be, will the poor man get bail in Agyei Baffour's OSP? Will a poor man get bail in Agyei Baffour's OSP? It's very ridiculous, very unreasonable, the terms of it. And when you look at, you cannot isolate this from the historical antecedent in terms of Mr. Adom-Otchere's relationship with the OSP. You know, nobody is saying that give him preferential treatment. However, if you don't also approach it very well, then you leave no one, you leave us with no choice than to conclude that this is just to show him where power lies. And it is unfortunate because that's not the reason why the power is given to the special prosecutor.
So I want to understand what you mean by, will the poor man ever get bail under Agyei Baffour's OSP? Can you elaborate on that? What are you trying to say?
If you are asking for 2 landed properties in a person's name before you give him bail, then question will be, will a poor man get bail from the OSP? It's very ridiculous. The whole essence or the whole philosophy behind it will be defeated, because the whole point is about making sure the person, when required to come to court or when required to come to you, will definitely come, right? And so you have to look at it on a case-by-case basis.
But Agyei, can you confirm that Paul Adom-Otchere in fact does not own landed properties? And if so, what does that even apply about his...
That is not material, very respectfully. The materiality of it is whether or not, without those 2 landed properties, the object behind a person needing to satisfy such terms will be met. That is what is material. Whether or not, in the absence of it, the philosophy or the object behind the bill will still be met. In my humble opinion, under no stretch of imagination would you think that someone like Paul Adom-Otchere who would jump bail without taking such properties from him. Under no circumstance, by no stretch of imagination. That is the reason why the terms are unreasonable and clear evidence that the OSP simply wants to show Paul where power lies.
So let's pause here for a bit. This is what you have to say. I'll come back and we'll probe the matters. I also have Justice Abdullahi. He's a lawyer and a lecturer, UPSA Faculty of Law.
My regards to him.
Justice Abdullahi, thanks for joining us on this conversation. So, Justice Lawyer Baffour Awuah, Agyei Baffour Awuah, is saying that it looks like the poor man cannot get bail under Agyei Baffour's OSP, and he's making reference to the fact that he was supposed to, Paul Adom-Otchere was supposed to present 2 landed properties, and he was not able to meet those requirements, for which reason he's still in detain. He has been detained together with 2 others. What were your initial thoughts when this information came to light for you?
Thank you so much. And my deepest regards to my brother, Nana. Nana is my good brother, so if I need to extend my deepest appreciation to him. Indeed, on this note, I was completely shocked, first off, when I heard that Paul has not been able to meet his bail condition. And so naturally, I was asking myself several questions. What could have been the conditions such that a person like Paul couldn't be able to meet them? It's a bit troubling because, first off, bills are not supposed to be used as weapons to target individuals. That is not the essence of bail. And as rightly put by my friend, bills are supposed to ensure that the person is available as and when he's needed, but not as weapons to target people and then show them what you can do to them when the appropriate circumstances avail itself. And so, I mean, to that extent, I completely agree that the whole news was a bit shocking, but when the details started coming out, it sounded a bit weird because these are not the normal bill terms that you would find. Typically, what you would find is that bill conditions, even if it's supposed to be justified, it can be the justification can be in the name of any other person, i.e., if you are using a landed property or you are even depositing a check, or individuals are standing in sureties for you. All these can be done without necessarily the property or the check or any other thing that is being used as a security for your release.
Because you're talking about the details, I'm tempted to add that, I mean, these 2 landed properties were not supposed to be of any required or specific value. So
that part of it was itself a bit problematic because
so how then can we say that it's too big or it's just too much, something we've not seen before, if they didn't attach a specific value to these?
You see,
that is not even an issue actually. That is not an issue at all.
Okay.
To insist that the property be in the name of the person would mean that you're not just bringing in what's it called, an indenture, as we popularly call it. You are bringing in a land title certificate registered in the name of the detainee. And that cannot be something that ordinarily we do here in this country. I've never come across that anyway, regardless of the value attached to the property or not.
So what then is your reading from this? I mean, you are saying that it's never been done. What conclusions did you draw from whatever the intention is behind such requirements?
At this point, we can only guess, but we can never be able to determine exactly what the OSP is driving at.
Yeah, but what do you see?
The only guess at this point would be that it is designed to keep him in custody. That's the only guess, educated guess that you can come to. And this is so also because Paul is quite known in this country. And even though one may want to use the former finance minister as an example of people that may be known but will still escape, I think there can still be better means of getting him secured and still be out there on a bail. There are a lot of other means that you can use, not necessarily having to buy a property in your name, duly registered and titled. I think that is too much to ask.
Okay, hold for me. I know Agyei wanted to say something. You say that your personal reading into this matter is it looks like the requirements were designed to keep him detained. Agyei, what do you say? You wanted to come in at some point.
So, like Shakespeare puts it, there's no art to tell the mind's construction on a human fate. Indeed, even in the courtroom, judgments are made from facts based on how the facts look like. And so, without more, we are then led to conclude based on the available facts. There's one thing which is not in dispute from this discussion. My brother just told you that from the facts, it is obvious that the whole thing was designed to keep Mr. Adom-Otchere in custody. The fundamental question then will be, why would anybody want to keep Mr. Adom-Otchere in custody? Clearly, it is to settle scores. What do we know about the relationship between Paul and the OSP? Paul has been very vocal in the way and manner the OSP carries out his business. Okay? And so, clearly, you leave us with no choice than to conclude that it is on that basis that the OSP wants to show where power lies. In fact, if they say that the property it should not be of a specific value, there's no property which is of no value in this country. With the greatest of respect, the property, even in my mother's village or my village, Agyei in the Kwabre district, right, is of value. And so it is not strange that a person cannot, right, produce two properties, right? It is not strange. Every property is of value, okay? And the mere fact that a person cannot produce a property is no basis to keep that person. The fundamental issue at heart should be whether or not the person, if required, would be available. Where would Paul Adom-Otchere go to? Where? That you have to keep him overnight. In fact, when you look at even the facts, which is the matter at hand, which is being considered by the OSP, it is even laughable, ridiculous. Look, you have to consider this from the corporate perspective and also the public procurement perspective, right? What role will a board chair play in procurement in this country? Unless you have a letter where the board chair himself wrote to secure approval for a procurement process from the public procurement authority.
So, you see, Agyei Baffour Awuah, you asking that we probe the whys, and so let's do that. And you're also saying that when you go down into the details, it looks like this whole case is laughable. I'm quoting you verbatim here. Now, we know that Paul Adom-Otchere is under investigation in connection with some revenue assurance contracts between Ghana Airports Company Limited and a private firm owned by the proprietor of Strategic Mobilization Ghana Limited. That is SML, right? Now, the OSP is examining the possible procurement breaches, including a sole source contract awarded to a company other than the one approved by the GACL board. Now, at the time, Paul Adom-Otchere was the board chairman. He has not denied, and I want to quote, right, so this is coming from Office of the Special Prosecutor. They are saying that the immediate past board chairman of GACL, Paul Adom-Otchere, did not deny the allegation by management of the Airport Company Limited that he brought the shady company. And he also confirmed that the procurement process for this contract started at the board level. Why would Paul Adom-Otchere not be the ideal person to be answerable for these investigations or questions that we need answers to?
So let me explain to you something. Assuming the fact they have even put out is true.
Are you saying this is not true? Because if you say assuming, it means you don't think it's true.
No, wait.
Okay,
assuming,
go ahead.
Assuming, because these are, what they have put out is their version of the facts. We know that they have put out versions of facts which have turned out not to be true. It is on record. It's a matter of public knowledge that consistently the OSP has put out facts that have turned out not to be true. The OSP put out facts in respect of Cecilia Adapa and canvassed it, went on a public rally, right, with it, only for him to tell us that it is not even within his domain. It is within the domain of Yoko. Then Yoko sent it back to Yoko, then rejected it. The OSP put out facts in respect of the late La Bianca. And we didn't see the head or tail of it in the end. There are several facts the OSP has put out that leaves much to be desired. And so in terms of facts that the OSP put out, if the historical antecedent is anything to go by, then clearly, very respectfully, there's much to be. We need to interrogate it further. We don't have to take it as gospel. But assuming without admitting that you even take it on the face value, if I introduce a company to you, assuming that I even introduce a company to you, that doesn't mean that I have, I'm involved in the procurement processes. There are clear procedures in respect of the procurement. The chief executive as the head of entity will initiate it by writing, if it's sole sourcing, he will write a letter subject to the approval of the board. He will write a letter to the Public Procurement Authority to obtain the necessary approval. In this case, even if Paul introduced the company to GACL, did Paul write the letter or put a gun to the head, very respectfully, of the chief executive of Ghana Airport Company to write a letter to the Public Procurement Authority to procure the necessary approval? You see, all these things, without more, doesn't mean that there's some wrongdoing. And procurement processes are documentary.
But
so,
Nana Agyei,
if you are minded,
while I appreciate the argument you're making, and I actually agree with you that we should probe further. Whatever the OSP gives us is not the final. I mean, we should probe further. But in probing further, does the onus not lie on a board chairman to actually verify or authenticate the credibility of a company before he introduces that company? And mind you, this is a company that had only one employee at the time.
Sure.
Are you saying that this didn't look fishy in any way?
Wait, these are facts the OSP has put out. Even if we are to take it as gospel, right, the head of entity has a responsibility to ensure that proper due diligence is done before writing to the Public Procurement Authority to procure the necessary approval. And that is not the board chair. The head of entity ought to have done that. And so it is not as if there is a statutory responsibility on him under the Procurement Act, which was briefed. But assuming without admitting that that is even so, let's even admit that he is even wrong. The OSP is not the court of law. If you are convinced that he has done any wrong, you take him to court. Charge him, take him to court. Are you getting me? That is the whole point about bail proceedings at that level.
Okay.
But to impose bail conditions in a manner which will keep him in bail, in custody overnight, right? Clearly, it is a complete abuse of power. And that is the reason why some of us have been on this public advocacy against the Special Prosecutor's Office.
Okay.
It is not just that. It is more. Look, it is a very dangerous outlet.
Agyei, hold for me. Let me also bring in, just to stabilize.
Wait, let me finish, because if you don't let me finish, I'll be taken out of context.
Go ahead.
When Mr. Martin Amidu was the special prosecutor, he prosecuted only one case. That case was against Mahama Ayariga, the majority leader, and a friend of his. Go and check the facts. Very ridiculous circumstances. It is an office that can easily be used to execute people and settle scores. If you don't have a very reasonable, mature person occupying that office, when the Commission for Human Rights and Administrative Justice was set up, it was put in the hands of Mr. Emil Short. We saw what he did with that office. Can we say same with the Office of the Special Prosecutor? It is a very dangerous thing that we have done. And besides, we are not even getting value for money. It has become a commercial enterprise to settle scores and do other things. And so we need to be very careful as a country. Our emotions are being exploited. Everybody knows that when you talk about corruption, you work up the emotions of Ghanaians. Everybody in this country is aware.
Right.
The moment you talk about corruption, the emotions are worked up.
Okay.
It is what has been exploited by the Office of the Special Prosecutor, particularly under Mr. Agyei Baffour.
All right.
That's what he's done.
Okay, so now we can hold on now. Justice Abdullahi, do you agree with the assertions of Agyei Baffour Awuah? He says that the board chairman is not directly responsible to verify or authenticate the credibility of a company he just introduced to the board. And he's also saying that the OSP's history gives us reason to probe further everything they tell us, so we shouldn't take their word as gospel. What do you say? I mean, you've been listening to him throughout. So what do you say to, well, how do you respond to
yes, Thank you. So, to say that an institution set up by the state with all the resources, indeed set up by Parliament, should be treated with some amount of disrespect would not be an argument that I'll go by. I can understand that institutions of state have problems. That I agree with. I mean, that is what I hear him to be saying. And that is not limited to the OSP. Almost all our public institutions have their own challenges that without doing so much to build them up, we all have problems. In the past, I particularly had to, a lot of occasions to question how not just bail, but the misuse of the powers of the Attorney General in entering noli prosequi and rearresting offenders when they are discharged by a court of competent jurisdiction. I would cite the example of Paul Afoku, who continued to be in detention even after he had been granted bail on about 3 different occasions and had been discharged on a couple of other occasions. Yet the Attorney General at the time did everything to keep the man in custody for well over 7 years. The man was still in custody. I do not know whether he's out at this point. And so if you are really attacking our public institutions, then we should look at it holistically, how our public institutions have worked against all of us, whether in the past or possibly in the present. And so those are question marks that we should ask of all other public institutions and not necessarily just the OSP. The OSP would have its own challenges similar to all other public institutions. And so to that extent, I would think that we will have to look at everything holistically because we tend to abuse our discretionary powers in this country more often than not. And then we use them to target opponents and dissenting opinions. That is what I would say with regards to that. Now, with a second angle of it, as to the role of a board chair, the OSP and most of its staff, the head are lawyers, like Baffour and I. We are both lawyers. I do not think that they do not know the role of a board chair. I mean, I think these are basic corporate governance issues that we all have basic working understanding of. The role the board plays, the chair plays, and the role of the chief executive plays. I think these are well known. And so from that angle, my point is that if the OSP invites the board chair, there must be a good reason. I would want to take it from this positive angle, that there must be a good reason why the board chair will be the one to be invited rather than the chief executive or the other board members. And so for that matter, I would rather the fact come out first before condemning the OSP as to why the board chair was the one that was invited rather than the board secretary or even the chief executive or other board members, because it is basic working knowledge that indeed the board chair sits at the board without taking the ultimate. In fact, he may take ultimate decisions, but the workings of the company they are done largely by the chief executive. And so, if the board chair is invited in such a manner, let's rather play. I mean, we shouldn't play the ostrich, but we should play with caution. Let's wait and see. Yes.
Does it suffice that one, he introduced the company, Evertex, to the Ghana Airports Company Limited, and that their engagement with this company started at the board level? Mind you, this is a company that they were trying to bring in because they said they lacked capacity. And the company they were bringing in had only one worker. So are these reasons enough to maybe hold the former board chairman before the OSP and say, we have questions that you need to give us answers to? Does that suffice?
Absolutely not. Absolutely not. Rather, could be a reason to invite any person would be how the Ghana Airport Company dealt with that company without doing much due diligence on their background. But let's also remember that having one worker or 100 workers cannot be a basis for anybody to be invited. If I dealt with a company, so long as the company is capable of delivering, the number of workers the company has is not considered. In fact, it's not a crime. It's never a crime that the company doesn't even have a worker, but it exists and it operates as it should be. A company may exist and be used outsourcing all its activities. So long as it's able to deliver, the number of workers it has is absolutely needless in determining whether or not a crime has been committed. And so,
what about, that's another one. What about awarding a $141 million contract to this same company to provide revenue assurances and, to some of these government officials and the rest? And the figure in question, is that enough reason to want to ask questions? Because the board chair, again, is the one who seemingly who knows these people, the Evertex guys. He's the one who brought them into the fold. Is that enough? The amount of money in question.
First, the amount of money. Second, the knowledge of the board chair. None is a crime in this space. There must be something more to the knowledge and the amount involved to amount to a crime. None of what you've said amounts to a crime in any way or shape. And so, like I said, we need to really know exactly what has happened before we can even impugn any form of criminality. But everything you've said so far does not in any way suggest the commission of a crime. Because crime is well defined in our laws. Procurement breaches are well defined in our laws. And so if one says that there are procurement breaches, what I understand the person to be saying is that the due processes in awarding the contract were not followed. That is, but not necessarily because the company involved was introduced by the board chair or by someone else, or the company involved.
That's what the OSP is saying. They are probing procurement breaches, right? These are just the fallout of some of the reasons.
Absolutely. So procurement breaches, yes, amounts to a crime, but not the number of the number of workers the company that was awarded the contract has, nor the amount involved. None of it amounts to a crime in itself, with that much to say.
Okay. So in conclusion, you think that it is against the laws of the land that Paul Adom-Otchere and these two others are still in the custody of the OSP? Is that
Unfortunately, I'm unable to accede to that, except that I would say that it's an abuse of the OSP's powers, but it's not against the law. Our law allows a person to be kept in custody. In fact, in this particular case, he's not even being kept in custody. He has been admitted to bail. Except, unfortunately, he's unable to meet the bail conditions. So there's absolutely no breach of the law, but the bail terms are unreasonably harsh against him.
Thank you, Justice Abdullahi. And Agyei Baffour Awuah, we have some time for your final remarks on this topic.
Okay, so to begin with, I never said that the OSP should be disrespected. I am saying that on the basis of the OSP's own history, of facts that it has put out, which have turned out not to be true, right? You then have to do more than accept what they give you. I think it is only fair that if somebody consistently is giving you facts, which turns out to be otherwise, or which tends to be more, require more, interrogation or probing, then of course, any other facts he brings out, it stands to reason that you need to probe it further.
Right.
And so I never said that it should be disrespected. Indeed, it is not just the OSP. I've also in the past raised questions about certain facts that the police itself have put out. For instance, if you recall, there was a history about some a policeman that was shot dead, involved in an armed robbery case. The manner in which the facts were put out, I was publicly raised issues concerning it. And so I have always raised those issues. The second point is, If my brother admits that the OSP is abusing power, then clearly the OSP is acting unlawfully. You see, you can act within the law, but in the process of acting within the law, you can act contrary to the law. Why are we saying this? When you look at the laws of this country, even where you have a discretionary power, you have to act in a manner which is candid, which is reasonable, and not arbitrary. Where you have admitted somebody to bail, but you impose conditions which right-thinking people look at it as unreasonable, as unwholesome, right? Clearly, you are abusing power. Is it consistent or is it lawful for a person to abuse power? If it is unlawful, then he's acting unlawfully.
Right.
And therefore, he's acting against the laws of this country.
Okay.
And so to say that he's not acted against, contrary to law, very respectful, I disagree with my brother.
Thank you.
My conclusion is that we need to begin to look at the OSP's office again. I've maintained that look, we need to look at it. Otherwise, we seem to be putting machete into the hands of people who are not acting in fidelity to the OSP Act. The very reason why we set it up.
Okay.
The very reason, I don't think they are acting consistent to it.
Agyei, that's our time. Thank you so much for joining us. We spoke to Agyei Baffour Awuah. He's a lawyer and member of parliament for Malaysia South. We also spoke to Justice Abdullahi. He's a lawyer and a lecturer, UPSA Faculty of Law.